Yes.
Well, can we move to the section of the judgment directed to the economic adjustments of Mr Mellor? So it's only at this stage the judge moving to a point where the numbers he's looking at can be directly compared as between different licenses. And this section begins by identifying the three adjustments put forward in 735. So that's the foot of page 183. And records at the start of 736 the fact that the principle behind the first two was agreed, the third disputed. And the principle were the two were basically, as I was trying to explain to my lords this morning, how Mr Bazant sought to deal with much the same issue, and that's why they were agreed, those first two. Of course, the detail of what they were doing was in issue, and the judge considered the adjustments for the different mix of cellular standards first. This is paragraph 738 onwards, where he describes what Mr Mellor did first. We can see in that paragraph 738, we're looking at only the Lenovo 6 now, not the Lenovo 7. And the judge records a point I've emphasised already, that the adjustment was done separately for past and future sales. You see that in 738, 3 lines from the end. You can see another point I've emphasised already. In fact, we see that different ratios are applied for the past and future by looking at 741, where the past ratio for LG is 0.914, where that applied for the future is recorded at the end of para 742 is 1.072, sorry, 27. And so you can see that they're different for this single adjustment. And the dispute between the experts was explored by the judge. My lord will recall Mr Bazant had separated out separate rates for each standard of generation. And we then we see that referred to in 745. And the judge, this is now 746, explains that neither approach is perfect, but he's preferring Mr Mellor's approach. And again, of course, I do not challenge that. The second adjustment, so the second agreed in principle, even though the details in dispute, is addressed from 747 onwards. That, as my lords know, is directed to the different geographical mix between emerging and therefore cheaper markets compared to developed markets. And the third adjustment, related to patent coverage, is addressed at 761 onwards. If we look at 773, we can see that in the course of writing his judgment, the judge asked for more analysis. And he summarised his further request by asking first, so I'm looking now at the two requests. The first one is whether it was possible to apply the logic of Mr Mellor's adjustments to blended rates of past and future. So we see there the point I made earlier, in fact, that Mr Mellor had not in fact done that to his blended rate, insofar as it was blended between past and future for adjustment. He didn't actually adjust that. He adjusted the past and the future separately and then blended them up together again. And it's not until after this request that you ever see Mr Mellor seeking to put forward adjustment ratios that could be used on his unadjusted blended rate. And in fact, those ratios are different again, because you calculated them by blending up over periods which were not past and future exclusively. So that's the first request that the judge made in the course of writing his judgment. He then also, the second request was for further refinement of separating the analysis into 3 fixed periods. So instead of having something which was determined by what was the past and future of a particular agreement, he asked for fixed periods to be addressed. And he was presented with further numbers that helped him on that. If we look at 784, we are into the section where he deals with Mr Mellor's weighting process. Now, key for our purposes is the fact that the judge concludes that it's too crude at 788. So if you look right at the bottom of the page, you can see that. And he says it places far too little weight on the best comparable LG 2017. That's at the top of 195. My lord, that leads me to the key section on the conclusion as to the comparables at 793, where the judge reiterates that LG is the best place to start, and he considers the other licenses in the Lenovo 7 one by one and rejects them, all accumulating in the paragraph that I've already shown you on page 199, para 811. Now that is, I think, as far as I needed to go to show my lords the shape of what he was determining at different points and emphasising the key findings that I rely upon that are not in the key section. The absolutely key section for my appeal is what I want to turn to now, if I may, and that's the paragraphs beginning at 391 onwards. So if we could go back to 391 on page 114. And what we're looking at here is a significant part of it is the section headed "The Approach to Past Sales," but then actually some significant part of the following section entitled "Frand General Principles" that starts on page 123 at para 427. Important parts of the judgment stretch right up to para 457. Now, before I start looking at it, can I ask my lords to keep the following points in mind as we look at this, please? The first is the point that I've already foreshadowed, and that is the need where in real life there's been heavy discounting from past sales. One needs to do both of the following two things. Not to replicate that in the future in the Frand agreement you're settling, and secondly, remove its effect from the information one's using as a comparable. So there's both a forward and a backward-looking aspect of this, and they are two different points which need to be separately addressed. So I want my lords to have that in mind, and the second point I want my lords to have in mind is this. It's the important distinction I've referred to before between the effect that heavy discounts for past sales will have had on the overall lump sum, that one thing, and the different point as to any effect that may be introduced by a possible inaccurate assessment of the size of those discounts. And let me illustrate the distinction I'm making. The judge held, and there's no appeal by my friends nor could there be because it was common ground, that there was a practice of significant discounts for past sales. It's a real thing on the judge's findings. And that will obviously have an effect on the overall lump sum paid, depending upon how the quantity of units in the past pan out and precisely how heavy one perceives the discounts to be. That was the point of my worked examples, to show that. And if you're of the mindset that one should be averaging across all units to get a weighted average quotes price, the average paid for the unit, where you're including both future and past, will be depressed by that heavy discount. That's the first point. But the accuracy of the measure of the effect is a different point. One can have a measure of what the past-future split that's bang on the money, or one that may or may not suffer from some degree of inaccuracy. And this question of the accuracy as to how one measures this real effect of heavy discounting for past sales is a different point. They're obviously related, but it's different. And just to explain to my lords why this is important, as you know, the experts agreed that there was in fact a difference between past and future pricing, and that was a very significant difference. And as we've covered, both split their calculations into past and future to take account of it. But Mr Besant's measure had the effect that a higher proportion went to the future. Mr Mayer's approach to the measure of this effect, the 10Ks, gave a different split, but still recognising the very real thing of heavy discounts for the past. And as we've seen, it was important for Mr Mayer to do that for the accuracy he thought he could get, because his adjustments were calculated differently for the past and future. But as regards the point on the accuracy of the rival experts' assessment of which portion to attribute to past and which to future, that dispute between the two is different and much narrower. Mr Mellor was of the view that Mr Besant's approach inflated the future rate that he derived compared to his calculation using his measure, the 10Ks. Now, why am I spending so much time explaining this? Well, as I foreshadowed at the outset this morning, the judge has muddled up this dispute about Mr Mellor thinking Mr Besant's future rate was inflated with the very point of principle as to whether one should take the weighted average across the units, including the depression that you get from the past. So he's muddled up those two disputes. It was a much narrower dispute between Mr Besant and Mr Mellor as to how you did the allocation and what your future rate was. And as we go through, you'll see that he's muddled that up. The scope of the dispute between Mr Mellor and Mr Besant on the use of their respective approaches is as between the measure of the allocation one gets with the 10Ks or what one gets from the documents Mr Besant used. And in fact, perhaps also from a dispute about what the precise number of future units was. But it was a narrow dispute. Let's say it's a dispute over whether the measure of heavy discounting is to apportion between the past and future in the ratio of 90-10, as opposed to 95-5, or perhaps 85-15. What resolving that dispute should not involve is throwing the baby out with the bathwater and saying, I'm not going to recognise the substantial effect that I've held is a real thing at all. And it's all the more troubling in my submission, as I've said, because the measure my friend's expert was using, the 10K, was the subject of evidence from our side as to how they were following important fair accounting rules, and that the accounts were audited, all of which was accepted by my friends, perhaps not surprising because they were relying upon it. And my point at this stage is just to highlight that this dispute between the experts over the allocation between past and future was very limited, just as to which way you did it, and Mr Mellor's view that Mr Besant's approach gave an inflated future figure. But it wasn't as to recognising that there was a very significant difference between the pricing for past and future, that it was in fact happening. Of course, Mr Mellor had his further point that one should average at the end, but that's because he considered the aim of the game was to reflect the totality of what was agreed as an average, regardless of whether it included a non-Fran distortion. So that second distinction is an important thing to bear in mind, because you'll see that the judge muddles that up. And in fact, he himself says he can't understand why the experts did particular things, because he's muddled that point up. With that introduction, can we turn to the key parts of the judgment that I really want to work through and look at in some detail, if I may. So I want to pick it up at 391, if I can, on page 114. And we see the judge introduces this topic by noting, rightly we say, that the approaches of Messrs Mellor and Besant to past sales were similar, although not identical. So this is under the heading, the approach to past sales. And the first thing he notes is that their approach was similar, and indeed it was. He then turns to various aspects of the evidence on this. Paras 393 to 397 cover the evidence of Mr Merritt and Mr Javaharian. The latter is Lenovo's licensing expert. The former was an executive from my clients since retired, I think. Mr Merritt's evidence set out in Para 393 is explaining that InterDigital in fact did discount past sales and explaining why. And the evidence of Mr Javaharian was seeking to argue for the availability of discounts for past years. That's the essence of the evidence covered in Paras 394 and 395. Lenovo also wanted to argue that the headline rate that one took from unpacking should not be assessed by excluding past sales. That's the substance of what is being advanced in the point set out in paragraph 396, so on top of what Mr Javaharian was saying. And the judge says pointedly at para 397, see the last sentence, Lenovo can't have it both ways. As as I've already foreshadowed, they wanted, as it were, to double dip to get the effect of the real life heavy discount, both in the assessment of the headline rate being depressed by that effect, and then all over again by having their past sales either not paid for at all or as a fallback paid for at a greatly reduced rate from the headline rate. My lords, just to be clear on my submission, not only can Lenovo not have it both ways, as they were seeking and the judge was alive to, they can't have it either way, because it is a non-Frand effect. Well, the conclusion that heavy discounting for the past is not Frand is absolutely right, but it doesn't mean it didn't happen in fact. Lords, the judge then turns to the evidence of Mr Bresky, which he summarises at 398 and 399, and that is the evidence that explained that the accounting principles followed US GAAP, which requires relative fair value allocation, as you see from the quote in the last line of 398. And as I've already foreshadowed several times, Mr Bresky was not required for cross-examination. Para 400 on page 117 of the bundle refers to the 10Ks, which make public the contributions from the larger licensee. And as the judge refers to here, and as I've foreshadowed several times, Lenovo's expert relied upon them. The judge also referred, this is para 401, to the evidence of Mr Grew. He was an InterDigital witness, and he gave evidence similar to the content to the evidence that referred to from Mr Merritt earlier. And then the judge gets into the expert's approach. We see he says at para 402, it's against that backdrop that he's just been covering that he comes to the expert evidence, which we've already seen at the outset. He summarises as involving similar approaches. Now he starts with Mr Mayer at 403, and he explains that Mr Mayer used the statements made by InterDigital in its financial reporting documents when unpacking a lump sum agreement that involved past sales release. That's a reference to the 10Ks that he's already referred to in paragraph 400. And if you look at para 404 at the foot of page 117 of the bundle, it explains what apportions were used. The key one is obviously the LG figure. And the sentence bridging the page break states that it's right to note that Mr Mayer's preference was for a royalty blended across past and future. And he goes on and states that, in other words, as that was applying the same rate to the past and future, it was not necessary to split consideration between past and future. Not necessary. I'll just pause here, because this is the first instance where you can begin to detect the judges muddling up the two different points. How you unpack a real life license, and then what you might do with the information you get from it. Mr Mayer's preference for using the blended past-future rate was at the end, and packing up the lump sum to apply to Lenovo. But at the earlier point in unpacking, he'd split the consideration to past and future, as I've shown you, including taking those forward to make his adjustments. And it appears the judge is not appreciating the difference here. It may well be the judge has overlooked that the adjustments were made differently for the past and future, so that they ended up with a different number. My lords, reversing to the judgment, the judge turns to Mr Bazant's approach at 405, and there's a fairly long explanation of how Mr Bazant approached it right through to 414. And it's enough for our purposes just to highlight a couple of points. You see at para 4061, Mr Bazant also looked to assess future-only rates. Para 407 highlights that there were two publicly available sources of information on the split of consideration, the 10Ks and the financial metric reports. Mr Bazant used the latter. There was also, as I foreshadowed a few minutes back, an issue as to how many units were to be attributable to the future. You see the differences set out in the table on page 119 of the bundle. The totality of the detail doesn't matter for our purposes. We can pick it up at para 416 on page 121. We can see from the first sentence, Mr. Mayor maintained his criticism of Mr. Besant's analysis. So the upshot was both had separated future out from the past, but Mr. Besant was getting a higher future rate. And you can see from the end of that first sentence, Mr. Mayor's point recorded by the judge, that Mr. Besant's approach resulted in what Mr. Mayor considered artificially inflated future rates. But let's just pause there. This is the dispute between the experts on this point as to the accuracy of the future rates. Mr. Mayor was criticising Mr. Besant, saying your rate's too high. It is not to do with the separate issue of whether one should blend higher future rates with lower past rates to get some weighted average. And I make that point here because the second half of this paragraph really is very puzzling, and in my submission relates to a muddling up of those distinct issues. So it's an important paragraph, my lords, and I'll be listening carefully to hear how my friends seek to justify it. We can see that the judge says that what is striking is that Mr. Mayor, in order to calculate separate rates for the past and future, was prepared to adopt the allocations made by InterDigital in its financial statements as to what proportion of lump sum considerations were attributed to the past, when these allocations were the primary reason for inflation of future rates. What we seem to have here is the judge introducing the idea that having accounting that recognises higher rates for the future to those for the past is inflation of future rates, in the sense that having a higher rate for the future at all is an inflated future rate. But it's certainly not the point that was between the experts as to how one best assessed the future rates that everyone accepted were substantially higher. So it's completely muddled up in my submission. And the reason Mr. Mayor was content to adopt the 10K allocations was because he considered them the best route to the assessment. And his criticism of Mr. Besant's approach, resulting, according to him, in artificially inflated future rates, is a criticism directed to the delta, or the difference between his future rates and Mr. Besant's future rates. So my submission is that InterDigital's allocation in its accounts used by Mr. Mayor is not a reason at all, let alone a primary reason for that point, i.e. Mr. Mayor's criticism of Mr. Besant's inflated future rates in his view. On the contrary, they were being relied upon by Mr. Mayor as the best way to come to an accurate assessment of the future rate as opposed to Mr. Besant's approach. It's completely muddled, that paragraph in my submission. My lords, if we move down the page to the series of paragraphs under the judge's subheading, My Analysis, we see the judge explains he is considering whether it's appropriate to treat past sales and future sales differently. And he just doesn't, at this stage, distinguish between that issue for future licences that he's going to settle and unpacking pre-existing real-life licences. And the first point he makes is recording a point I made, an obvious point that if a lower rate is attributed to the past compared to the future, it encourages delay by the licensee, and the longer it holds out, the less it has to pay. Just pausing there. That point is obviously directed to whether lower rates for the past should be put in a new Fran licence, specifically the one the judge is concerned with. It's nothing to do with unpacking pre-existing licences where that effect has already occurred. But the judge doesn't seem to appreciate the difference. He's moved to it from explaining this dispute between the experts as to their assessment of past and future rates when unpacking pre-existing agreements. And I certainly wasn't making a submission that one should ignore that it had actually happened in real life. As I've said to my lords a couple of times already, of course both sides were agreed you didn't do that. The dispute was simply as to the precise level at which the higher future rate came out, as we've seen. So the judge is muddling up those 2 points again. And he continues because he immediately flips back to matters that are relevant to the accuracy of unpacking the higher future rates. The judge says at 418, InterDigital and Lenovo presented different analyses and reasons, and says, fortunately, it's not necessary to resolve the differences between the experts on the treatment of past sales. 419, he summarises what he'd just been describing on either side's experts' figures. The royalty rates for past sales were very considerably lower than the future rates derived by either expert. And he notes the disparity being much greater in Mr Bazant's figures. That's noting that there's a delta. Mr Bazant had higher future rates than Mr Mellor. So we again see very clearly set out what was common ground, past rates very considerably lower than the future. And that's consistent with his finding that there was in fact heavy discounting for past sales. And what the dispute was how to put a number on that. And there was a delta between the two experts. At the risk of repetition, what this relates to is the unpacking of real life licences, not what one then does in a FRAN licence when settling it. What that paragraph's concerned with. 420 is important. This is where the judge notes that both sides' experts were content to adopt in one form or another InterDigital's allocation of the lump sum consideration between past and future. I might interject here, there are in fact 2 points rolled up here. First, the experts both recognised that there was in fact a substantial difference between past and future. And secondly, that the way each chose to put the best measure they could was to look at InterDigital's allocation in one form or another. Both those points are rolled up there. We see the judge says that that common ground gave the judge considerable pause for thought as to whether he should depart from their effectively agreed approach, at least at that high level. And it doesn't appear as though the judge is realising that what he's considering doing is departing not only from the agreed use of some InterDigital allocation or another between past and future, but departing from actually reflecting the agreed substantial difference between the past and future at all. He's focused on the fact that both of them have used something that he can say is a subjective allocation. But as we see, what he's contemplating doing is not just departing from the agreed use of an InterDigital allocation, but departing from actually reflecting the agreed substantial difference between past and future at all. And we see the judge goes on in para 420 and says he thinks the experts were each doing what they were doing for different reasons and because it produced different effects. He says Mr Bazant's adoption of InterDigital's past-future allocation favoured InterDigital's case because the effect was to increase future rates. That's the end of 420. Again, we just need to pause and consider that. It might seem as if he's focused on the increase in future rates that came from the particular details that Mr Bazant used to derive his future rates. So to get that higher rate than Mr Mellor, so on the delta between the experts as to what the best assessment was. But as we shall see, the judge may have been muddling that much narrower point with recognising that substantial difference between inflated rates for the between rates for the future and the heavily discounted rates for the past at all. At 421, he turns to Mr Mayor and says this, that he kept in mind that Mr Mayor favoured an overall blended rate, but to the extent that he derived different rates for past and future, his adoption of InterDigital's allocation favoured Lenovo's argument that whatever it should pay for the past should be heavily discounted for the past to avoid discrimination. So the point the judge is making is that Lenovo was relying upon this feature of heavy discounts in real-life licenses and saying it should get a heavy discount rate for all its past sales, which we know for Lenovo was a huge proportion of the total units. And that's a fair point to note as to what Lenovo was seeking to do. But again, the judge appears to have failed to appreciate that what they were focused on was arguing that the heavy discounts for the past should be reflected in the FRAND license he was settling. And that his conclusion that it was not FRAND to do that does not mean that one should ignore that the non-FRAND but very real effect in real life licenses needed to be addressed when unpacking them. Actually, the judge seems to be focusing on the way in which this very real effect was being quantified, the allocation by InterDigital one way or another. Something that was a dispute between the parties as to which way you did it, but not that there was in fact a very significant difference between past and future. And we shall see that his solution is simply to ignore the real life effect completely when unpacking. Paragraph 422 explains that the judge's conclusion is that it's incorrect to proceed upon the basis of subjective assessments made by InterDigital of the proportion of a lump sum which should be attributable to past sales releases. So again, the focus of the judge's criticism is the nature of the information used to assess the actual difference between the rates for the future sales and the past ones. He goes on, this is bridging the page break, to say that it was evident to him that these assessments were made by InterDigital, at least in part, in order to be able to quote higher future rates. He says whether there were other justifications doesn't matter. And also that's a pretty serious allegation to be levelling at my clients. It's described as creative accounting later in the judgment. I think I've already given you this reference. 926. And as I've already foreshadowed, it's particularly serious when on this particular issue, their explanation was they were following the rules that required a fair allocation, and which was, their evidence was accepted without challenge. Because it's clear from the rest of paragraph 4222 at the top of the page that what the judge is talking about here is not simply the precise level might have been a little bit higher than, say, another person seeking to make a fair allocation might have done. He's actually talking about having a difference for past and future at all, even though in other parts of the judgment he accepts that there was in fact that effect. Now the reason I say that he's talking about reflecting any difference at all is if we read on, we see he's now not simply referring to the leeway where one might have a bit of leeway to argue about whether one party recording its allocation is quite right. He's referring to the very fact of a difference between past and future rates at all. You see, he says what matters is InterDigital's assessment resulted in implied rates which are low, sometimes very low for the past and higher for the future. Just the very fact that they're higher for the past, for the future than the past. Just pausing there. That's what heavy discounting for the past is. Something the judge accepted in fact happened. The other side were relying on. So my submission is we say the judge is just wrong there to think there's anything wrong in that. At this level at least. Of course there might have been, and indeed there was a dispute about the precise details of the number one puts on it, but not that there was this significant feature in the agreement of heavy discounts for the past. The final sentence of the paragraph is worth looking at too, because what the judge says here is that it seems to him that the precise date when a lump sum deal is done should not affect the royalty paid per device. What he's clearly referring to there is the royalty per device should be the same if all the sales are future looking, compared to whether they're split 50-50, 90-10, whatever, like in those examples I gave to my lords. My lords, we both agree with this sentence and disagree. How can I have such a schizophrenic submission? Well, because if stated in the context of what you do in the license you are settling, we agree. The fran rate is fran for all sales, whether made in the past or projected to be made in the future. All of them should attract the same royalty. But we fundamentally disagree with this if one is stating this is a way to unpack agreements, where you know that the agreement has in fact incorporated heavy discounts for the past. Deliberately approaching each of those four agreements that I gave my lords as scenarios, knowing when there's different proportions of past sales, but to just ignore it. And that failure to appreciate that there are two different dimensions to this, which require different treatment, is actually also apparent in the next paragraph, 423. What the judge says here is that he proposes to adopt the same approach as in UPHC, that's Unwired Planet High Court, so that's you, my lord, and in TCL and Ericsson. And he says, and that's the same rate should apply to the past and the future. And he says that that's Mr. Mayor's blended rate approach. Let me just pause again. The reference to Unwired Planet is a reference back to a feature the judge identified at para 244 and sub-para 9. See that on page 70 of the bundle. What that sub-paragraph is noting is that although there was no issue before the court, it's apparent that the licence settled had fran rates applied uniformly to both past and future handset sales. So this is the point as to what one does in the fran licence one is settling. Not the separate issue of whether you ignore the existence of the non-fran feature in unpacking real-life licences. But he's mentioning it together with TCL, which is the other issue. If we go back to page 122, the reference to TCL, not the same point at all. It's to do with unpacking pre-existing licenses. That TCL case, as my friend relies on, is not the same point. That was where the argument before the judge was whether to completely ignore past sales or whether to unpack by including them at the same rate as the future. So basically the debate was whether to give them no value or full value, as it were. And the judge in that case decided to include them. But it's a point on unpacking. And just to be absolutely clear, my lord, so you know what my position is on that, my submission is TCL is wrong, at least in the context of a case with factual findings made here that the agreements have been subject to heavy discounts for the past. TCL simply didn't address the middle ground of an allocation between past and future to reflect the reality of some value being attributed to the past but not at full rate. But my submission at this point, perhaps even more importantly, is that this is the judge again 423, muddling up. By treating Unwired Planet and TCL as the same point, he's failing to appreciate that they're different. The one is what to do in the Fran license being settled now, and the other, how to unpack agreements that have already been entered into in real life. Two distinct points that require separate treatment. Can we look at the reasons the judge says he has for what he's going to do? He says there are two, which he says are cumulative and alternative reasons. So he's saying one is enough, but he thinks they both point to the conclusion he's coming to. As I understand it, the first reason is explained in paras 424 and 425. And the thrust of 424 is the judge explaining an impression he formed from Mr Bretsky's apparently lengthy explanations. Before we look at what the judge says, can I just show you what it must be that he's referring to? Because you're aware that Mr Bretsky was not required for cross-examination, so the impression is not from watching any prolix answers in cross-examination. It can only be from reading the statement that he filed. It's a short statement, the substance of which extends over little more than 4 pages. Can I show it to you, please? It's Supplemental Bundle C, Volume 1, Tab 1. He sets out who he is and how the statement's been prepared and his position in InterDigital on page 2 of the statement, that's page 3 of the bundle. The substance starts 2 lines from the foot of this page, page 3 of the bundle, and ends at the top of the page of page 7 of the bundle. Paragraphs 8 and 9 explain the accounting principles they work to. In fact, it's really only paragraphs 8 and 9, as para 10 simply sets the scene for the features that agreements may have that they have to deal with. Following on from this, he identifies the issue he's going to focus on at para 11. That's where there are past sales. Paragraph 12 briefly touches on running royalty agreements, and the bit we're particularly concerned with is paragraphs 13 to 19, the fixed fee agreements or lump sums. The last 4 paragraphs of the short statement are actually concerned with a different topic, how to assess non-monetary consideration. So the key passages are the 2 and a bit pages, paras 13 to 19 inclusive. And I'm not going to read it out because there's quite a bit of red, meaning confidential, but my lords will recall that we set it out in full in our skeleton at paragraph 44. And it must be these 7 paragraphs that the judge is referring to in that passage of his judgment, which he characterises completely unfairly in my submission as Mr Bretsky's lengthy explanations. Must be. If we return to paragraph 424 of the judgment, so you can put bundle C away, we see the impression the judge says he formed from Mr Bretsky's lengthy explanations was that InterDigital retained significant room for manoeuvre in the way it apportioned an overall lump sum consideration to a past release. And he goes on to say this was reflected in the past and future rates derived by Mr Mayor for the Lenovo 6. He also goes on around the top hole punch to say one of the consequences of the relatively smaller sums that InterDigital recognises as attributable to the past is that the relatively higher sums attributable to the future result in higher royalty rates for the future. He's going to go on and explain how they may be referred to, but before we look at that, can I just ask my lords to pause again? The thing the judge is identifying, said to reflect the room for manoeuvre, is actually simply just the very existence of the difference between past rates and future rates. The entire thing. it's not that he's saying there's a possibility it could be allocated a bit higher or lower than it might on a different view due to this room for manoeuvre that he says these accounting rules give InterDigital. It's the whole thing. Having a difference between past and future at all comes from this room for manoeuvre. If one stops to think about the consequences of this, what the judge must be suggesting is that even though they do heavily discount in relation to past sales, it would be fair and within the rules, and InterDigital could have allocated the same consideration to past and future sales, even though there was this practice of heavy discounting. That must be what the judge is suggesting. It was never suggested to Mr Bresky. In fact, the flavour of it, particularly later calling this creative accounting, is not just that they could, but actually they really ought to have allocated it without reflecting any difference at all. Again, my lords, we say the judge is jumping from a point that at most could go to the delta between the parties as to how one precisely, most accurately quantifies the difference between the past and future rates, to make it justify ignoring the substantial difference completely. The rest of paragraph 424 refers to the fact that InterDigital can cite the higher future royalty rates to other potential licensees and also in renewal negotiations. The reference to renewal must be to talking about the scenario where the licensee itself is coming back, so the one that's reported is then up for renewal with the same party. Of course, the judge is right, but no doubt parties to negotiations will look at what's been included in accounts to see what that translates to as to future and past rates. And if we're considering a renewal, both sides to that negotiation will know that there will be no past sales for the new licence. So none could be subject to the heavy discounting. That's the characteristic of a renewal. But both sides looking at this to see what it translates as to future and past rates. There's nothing wrong with that. And I might add, it does seem a bit of a tension with what the judge goes on to say in paragraph 425, which, after stating InterDigital's allocations were somewhat artificial, another serious point not put to Mr Bresky, he suggests a reason for rejecting the approach of reflecting a different past and future rate is because he regards it as more normal for others in the market to assess the rate derivable from a lump sum licence, to take the total consideration and divide it by the best estimate of the number of units covered. In other words, we're only talking about those licences reported in accounts where people can do this. And they can, of course, do what the judge describes. But they will know that they're looking at a deal which covers the past too. They need to do that to add in their best estimate of those units from the past. So they know what we can see in the accounts, and just as both sides can work out the past and future rates separately like Mr Mayor did, they can obviously work out a lower combined rate, and no doubt those trying to negotiate a lower rate will try it. And InterDigital may point to the fact that it's a deal with a significant past where many sales were heavily discounted. But simply ignoring the fact that an agreement does or does not have a significant element of past sales is to ignore reality. Going back to those examples I gave my lords at the outset would be to treat all of those deals in the same way as if they were all negotiated with no heavy discounts applied to any units, when in fact only one of them was. And as we saw from those examples, you get very different answers for a rate if you do it that way, depending upon what you're looking at. Even though, in every single instance, we know from the facts I postulated that the parties negotiated the same Fran rate of $1 per unit. Now, my lords, now is perhaps a convenient point to just pause and refer to LG's own allocation. And I say that now because the judge specifically raises the idea that InterDigital can manipulate things so as to be able to refer to a higher future rate than for the past, both for other licensees but also a renewal. So the same licensee coming back for a renewal, the judge is suggesting would otherwise be able to be saying, we worked on this basis that the judge likes, just ignoring the discounts and having a lower rate. The judge suggests it's normal, so even though that party knew that they negotiated on the basis of heavy discounts, they'd be able to come along and say, sorry, we actually negotiated on the way suggested in this judgment. Let's just consider that. My first point is that they would have to be pretty barefaced to do that. If they previously negotiated on the basis there would be heavy discounting for past sales, it would be likely all over the communications. But I'm sorry to say, in this field, it wouldn't surprise anyone if it was tried. Let's assume it was a negotiation of the kind I talked about, where the split was 90-10. So it was agreed that it was $1 a unit was frowned, but heavy discounting to 10 cents for those past sales. What the judge is suggesting here is that InterDigital would be saying we agreed $1 last time, as only 10% of the units were, last time as only 10% of the units were future, 90% were past. And the judge is suggesting there's something wrong with InterDigital saying that. And the proper thing would be for the licensee to say, look, 100 million units, I know only 10% were future and the rest were the past. But the total paid is $19 million, and so it's 19 cents per unit, even though this time round there are no past sales at all. It's the guts of what the judge is saying. Not only would that be quite extraordinary, given the party's history that we're postulating, this is a renewal, but the licensee might themselves have had to carry out their own allocation for similar reasons to InterDigital, which also reflected the reality of the heavy discounts of the past. And in fact, as I foreshadowed a few minutes ago, in this case, we know what kind of allocation LG was working to. Not because of any regulatory filing, but because of the way it structured what it was proposing. And we refer to this in paragraph 50 of our skeleton. You can see the way LG is approaching the question of split between past and future consideration. And it comes from a schedule that was in the papers. It was ordered instead of disclosure relating to these comparables, I think actually by my Lord Justice Birss when still a High Court judge early on in this action. Can I just show you that document? Just the pages we've got for LG. It's Bundle E, tab 12. And if you could move forward to page 151 of the bundle. And what my Lord ordered was, instead of giving disclosures, certain information that one could see in the correspondence. And so this was a schedule that was given in lieu of disclosure. And what we've got here on this page, on the right-hand column, is the licensee's last stated position. So it's the position before agreement. And you see how it was splitting its offered money as between past and future. It's highlighted in yellow, so I'm not going to read it out. But you can see it. We've given my lords what that amounts to in terms of percentage split in our skeleton. And actually, while you're here, you can see InterDigital's last stated position in the column before. So that's before the deal was done. And in fact, that gives a percentage split pretty close to the one Mr Mellor took from the 10Ks and used. But the point of me coming here is in fact twofold. First, you can see that in fact both parties were negotiating in a way that put forward a much lower consideration for the past. It is a real thing, as the judge held. It was a real thing in this case. And I can make the point that the licensee, LG, itself was attributing an even lower proportion to the past than InterDigital. And as we say in paragraph 50 of our skeleton, if Lenovo had taken this point that the judge now advances, that the 10Ks can't be used because they're too subjective, and put forward a picture for a self-serving end, we would have drawn this to his attention. But as we say in our skeleton, it wasn't, because it wasn't an issue. But the judge doesn't deal with it, because this is a point that he's come up with in writing the judgment. So it wasn't, that document was not drawn to his attention for the point that I'm making, but it would have been if we'd have got into this.
So, Mr. Speck, maybe I'm being thick and it may not matter, but I'm looking at the figures on page 151, and I can see on the right the number, the yellow number on the box for LG in row 2 is the higher of the two on the page is a bigger number than the one in the middle. I think the one higher up the page is for the future and the one in the middle is for the past.
Yes.
The fact those two numbers differ from each other doesn't tell you what the rate is.
No, but what I did it in an elliptical way. Paragraph 50 tells you what the proportion ratio between the two. X% is for the past.
Para 50.
Para 50 of our skeleton.
Oh, I see.
Sorry, I should have. I was trying to.
I see.
But the point, you can't read the proportions of this document, but what you can do is work out what percent was for the past and what percent was for the future, and that's the point I'm making.
Okay, thank you.
My lords, we submit it's quite wrong to think that the 10Ks are in any way materially unsafe, nor subjective in the sense the judge is suggesting, i.e. is not reflecting the real thing, that past sales were heavily discounted. And that was an understanding shared by the licensee. It's certainly wrong to conclude that the better course, the more accurate course, is to have no allocation at all to reflect this real life feature of agreements. Now that was a little bit of a diversion to highlight the LG position, particularly because they might have been a party coming back for renewal. My lords will recall that we were on the first reason the judge gave for his view, and the second reason that he gives is back in paragraph 426 on page 122. And I'm going to struggle here because I have to say I really haven't understood how this is a different point. But we'll go through what it says. What the judge says is that the plan should focus on the money and the benefits that pass, and it's not concerned with internal justification in the way it seeks to deal with sums in its accounts. The judge says particularly when the justification forms no part of the agreement. What he means there is it's not written down as part of what they've agreed. And he says at the end of the paragraph it is wrong in principle because it injects InterDigital's subjective view of the value.
To which you say, if it's InterDigital's subjective view, why on earth is just Mr Meyer relying on it?
Well, true, and I say that, but I also say at a different level, it's just not the subjective view in that sense at all, and I'm going to come on and explain that. But you're right, I do say that. But before we get there, my lords, can I just pause and make another point that relates to it's not in the agreement. The units that have been assumed to be covered are also not part of what's generally written down in the agreement. My lord's looking puzzled, so I've said something.
What do you mean by that?
The actual number of units that you're working to, one has to look at analysts and do projections. So what I mean is the agreement just says a lump sum for 5 years or whatever it is. So part of the analysis that I tried to explain to my lords at the beginning is that you're assuming that that sum is worked out by having a view as to the number of units that are going to be included in that period, and if it's for the past as well, how many sales have been made. And the point that I'm making here is a point on the judge particularly saying, well, it's something that's not written down in the agreement. It's not actually been agreed separately. Yes, he's right, but the units aren't either, is my point. They're not generally written down in the agreement. But we know...
So can I just check I've understood that point? So what you say is, in reality, people will have... They should have figures for the past. They might, in fact, not, but at least in theory they should have. They can't have figures for the future, so they will make assumptions or estimates. And that's a matter that goes into the negotiations. It's not written down into the agreement, meaning, if I've understood you correctly, in theory you could have a future license that was expressed by reference to numbers of units licensed. So we give you a license to sell up to 100,000 units over the next year. And if you sell 100,001, the first one after 100,000 is actually unlicensed.
You could do that. The point that I'm actually making is that you don't normally do that. What you do is you just have a license for 5 years.
Regardless of the number of units.
Regardless of the number of units, but there's a price, and the way in which everyone is working for unpacking is that you assume that the negotiators did have an idea of the units, and that's why you look at the analysts and the projections. So you use in unpacking units to do your sums that are not written in the agreement.
Yeah.
That's my point.
Do we have the agreement? The LG agreement?
Yes, I think we do. I think we do.
I have no idea what these things look like.
It's
E-tab 9, I'm told.
Or
E-tab. Go to page 62, the guts of the...
the grant clause is 2.1, I take it. And then the consideration is as specified in 3.1.
Yeah, exactly. And that's why when I was explaining the basics of what you're doing earlier on, I was at pains to explain to my lords that you're assuming that the overall lump sum was negotiated having an appreciation of the likely number of units that would be sold, and you have to have a way of assessing what that was likely to be. It's a moving part, one of the moving parts. It's not usually written down in agreements, and that's why it's common ground that you look to what people would have thought. You don't look to see what sales were actually made. And that's why often what you end up with is looking at analyst figures that are then projected out. And in fact, your lordships may have picked up that there was a wrinkle about which analysts they used, because Mr Bazant had used a different one to Mr Mayer, and then we eventually agreed that we used the same one that Mr Mayer had chosen. None of that's an issue before my lords, but the point that I'm making to my lords is that the very fact that something's not written in the agreement, you can't start suggesting that you can't take any account of what your understanding is going on, because you have to do that for the real basics.
Yeah, I think we've got that point now.
Yeah. Actually, the second point was going to be that Mr Mayer relied upon it anyway, so my lord's point. And can I just say this? You're not using the particular numbers written into the accounts because they're written into the accounts. It's the other way round. You know you should take account of this significant factor and the experts assess what's in the accounts as the most accurate way to do it. So overall, my lords, there's nothing wrong. Nothing in, actually, there's nothing in what the judge says in paragraph 426 either. And I have to say, in my submission, it's really just another way of putting what he's already said. Can we go over the page to the section headed Fran, the General Principles? The judge begins this section by identifying that he's considering what a willing licensor or willing licensee would agree. And that's the thrust of paragraphs 427 to 429. 429 in particular explains it's the approach both for the future period and the long period of sales before the Fran terms were settled. 430 points out that one of the complications here arises because of that long period before Fran terms will have been settled. And the judge explains several issues that arise that he considers are interrelated. And the first that he mentions is national limitation period. So that's paragraph 431 to 435. And he explains the position through those paragraphs, specifically drawing attention to the fact that Lenovo didn't plead limitation as a direct offence, instead saying it was indirect, the judge saying it was relied upon in support of the argument that it wouldn't be Fran for the agreement to require past payments of significant sums for past sales. And as the judge highlights at the end of 433, two particular circumstances were highlighted by Lenovo: the terms of other comparable agreements and the effect of arguably relevant limitation periods. And as the judge explained at 434, this was actually an argument that often featured in Lenovo's submissions. And it was this, that if Lenovo was treated adversely compared to how other InterDigital licensees have been treated in the past, that would be discrimination. And the judge pointed out that it was pretty selective as to when this mattered. Any difference in their favour they accepted, but any perceived adverse difference was branded as discrimination. Of course, the central point here is what to do about a market distortion that's not Fran, which, as I said right at the outset, is the underlying issue on all three of the main issues raised in the appeal and cross-appeal. And the basic argument Lenovo was running, and is still running, I think, is that if there's been a non-Fran market distortion adverse to the patent owner, and therefore advantageous to the implementer, you can't eliminate it going forward. In substance, the submission is we are in a position where we're stuck with it because, perversely, it becomes un-Fran to eliminate it in the Fran agreement being settled. And that really is the essence of the argument, my lords, that the judge exposed the fallacy in paragraph 435 by putting his point thus. It's assuming that all comparable licenses in which Lenovo relied were Fran in every particular. And this is an important paragraph because the judge makes it plain that it's not his view that that's a valid assumption. And crucially, the judge explains he doesn't have to slavishly follow the licensing practices of InterDigital that are reflected in those licenses. So this is an important paragraph. It's flagging up that there may be features of real-life licenses that are not Fran, and the court shouldn't follow them in that regard. Obviously, that's the only way non-Fran market distortions or features are going to be eliminated. So as regards part of the picture that concerns the need not to include a non-Fran feature in the licence that the court is settling, the judge is absolutely right. The issue, as I've explained, is his failure to see he also had to remove the non-Fran effect in cases where its positive presence was there in the pre-existing real-life agreements. Now at 436, the judge turns to the second related issue that he calls the Optis issue, and that relates to the time by when a commitment to take a licence on Fran terms is required. And here the judge is agreeing with the conclusion expressed in that case, perhaps it was before my Lord Justice Arnold told everyone it was right anyway, but I think he's focusing on what Mr Justice Mellor says, that when an implementer is first found to be infringing a valid set, they must undertake there and then to take Fran terms as may be determined later. This is obviously in the context of English proceedings. And I think I've already mentioned in that case, in this case, Lenovo had actually avoided doing that on grounds which rather evaporated by the time they get to trial. But the judge goes on in para 437 to explain that this requirement is no more than a particular manifestation of the position of a willing licensee and is designed to prevent or diminish holdout. But he also says it's only a partial solution to holdout and that the real solution lies elsewhere. And para 437 continues with the judge then making the obvious point that it would be possible to eliminate or significantly reduce holdout if there was no incentive for the licensee to delay reaching an agreement. And he explains the focus of this consideration. And they're two things: the influence of the limitation period and the resulting heavy discounting for the past. Whereas here the judge is expressly recognising again what is happening in real life, and in fact which was common ground, as I keep saying, and saying that it's that which is giving licensees an incentive to delay. And that's obviously right. If in real life you're paying nothing at all for old sales and a heavy discounted rate for those more recent but still in the past, why would any licensee want to do anything other than wait as long as possible so that more and more of their sold units fall in those buckets? Obviously right. Now the judge says at the end of paragraph 437 that in the jurisdiction which he is operating in, the solution to delay, whether all of it is attributable to holdout or not, is for a willing licensee to pay for a license to cover all past sales. And as we shall see, his view is that it should be at the same rate too, which will obviously deal with the second of the points that he just mentioned and was recognising, the heavy discounts for the past. And the final paragraph in this section, paragraph 438, suggests that as more Fran determinations are undertaken, any perceived differences in approach should converge. And the sentiment of this paragraph is that as time goes by, Fran should be easier to determine, even if you still need litigation to get the confidential agreements. Before we move on to the next section, can I just highlight what the judge is actually focusing on in these paragraphs, particularly in 437. And it's repetitive, I know, but he's focusing on how to frame the Fran licence that he's settling. The hoped for effect of that in the future. He's recognising heavy discounts as a feature of the real life sentence, of real life licences. But what he's focusing on is what to do about it in the future. He's saying the way to eliminate holdout is to frame a Fran licence differently and expressing the view, or hope at least, that it will have an effect going forward. But what he's simply not looking at here is any effort to remove the effect of that non-Fran feature from the agreements that are being used to set a rate. Just not looking at it. In short, my lords, the focus is only on one of the two things we say the judge should have been concerned with. Avoiding perpetuating a non-Fran feature, but not the other, removing its effect from the agreements being used. Can we move on to his section headed his analysis, where the judge takes a step back and explains that some of the points about the general picture that he, as he saw it. The first point he makes in para 440 is to identify what he understood as Lenovo's big point, being the objection to the size of the volume discounts that InterDigital say it applied. And please note, it's not volume discounts as such, it's their magnitude. The big point the judge identifies for InterDigital, this is 441, was the length of time Lenovo had been taking advantage of SEC technology without a license, and he explained that was at least part of our reason why our offer stipulated the same price will be paid for the past and the future. And he concludes at 442, in principle, what we were saying on offering doesn't seem to be unreasonable, and in fact chimes with his analysis above. He's referring back, as I understand it, to where he'd addressed the issue of why the basic FRAN rates shouldn't change at the date the licence was entered into. Those who recall, I drew that to your attention. And we agree. As I said, for a future licence, i.e. the one being settled by the court, we totally agree. But still the judge doesn't seem to appreciate the difference between that and how one extracts a FRAN rate from the existing licences where you have a heavy discount. And I say that because the judge then moves in para 443 to the other issue, the unpacking of existing licences, and says the problem with InterDigital's approach is differing rates calculated for past and future, and the subsequent demand for the inflated calculated future rate should also apply to the past. He also fails to keep in mind the other distinction I drew attention to, the argument between Mr Besant and Mr Mayer as to how that split ought to be assessed. So the argument about whether Mr Besant's rate was an inflated future rate failed to keep that distinction in mind between that and actually having a very substantially higher future rate at all. And the final sentence of this paragraph says it was Mr Besant's inflated future rates that were being used to attempt to justify the programme rates. My client's programme rates. My lords know, of course, we're not seeking to persuade my lords of Mr Besant's apportionment on this appeal. Simply Mr Mayer's lower assessment of the future rate. But this paragraph is deploying a reference to the delta or the difference between Mr Mayer and Mr Besant as to what the past or future allocation was or should be. So the reference to the inflated future rate, that's the reference to the delta. But the judge appears to be taking the issue as extending much further and extending to carrying out the unpacking to reflect the reality that there was a heavy discount at all. He's doing it again. I've already shown you him doing it earlier on, but he's doing it again. Or at least he's not clearly distinguishing between that dispute and that over whether Mr Besant's future rate was disproportionate or inflated compared to Mr Mayer's. So this, my lords, is another important paragraph where we see the judge segueing from addressing the issue of how to frame a future FRAN licence so as not to perpetuate a non-FRAN feature. That's what he's considering in the previous paragraph, para 442. And he moves to what is a separate issue as to how to unpack the existing real-life licences that have this non-FRAN feature. And at the same time, refers to Mr Mayer's criticism of Mr Besant's way of deriving a future rate as disproportionate or inflated, but without noting that that dispute didn't go to the very point of having a substantially higher future allocation as such, just that it went to the precise way Mr Besant had assessed it. And things get even worse, my lords, because he then flips back in paragraph 444 to a point that's again to do with how to frame the current FRAN licence that one's settling, rather than how to unpack. Para 444, the judge recalls Lenovo's initial position that nothing should be paid for the past, but this, what he calls a hardline position, was abandoned, and in its place they were content to adopt the practice of heavy discounting, InterDigital's practice of heavy discounting for the past, because it suited them, because they had a huge amount of past sales because of the very long delay. So he's flipped backwards and forwards between something that's to do with the future licence and unpacking between three different paragraphs there. And my lords, also please note this paragraph well, because I'll have something to say about how Lenovo seek to meet my arguments on appeal and how they've forgotten that this was their case, that it was common ground that the InterDigital licences had been subject to heavy discounting for past sales. So this paragraph is an important one. And the end of paragraph 444 is also worth noting because it reiterates the judge's view that this heavy discounting for the past was a real thing. And he explains what was behind it. You've seen it before, the influence of limitation periods around the world and the difficulty in recovering damages for infringement. So it's a real thing. And you can understand why the judge's view was that it wasn't FRAND, a conclusion we pray and aid. Of course, the first half of this paragraph is referring to Lenovo's wish to have a FRAND license that reflected that practice. Because it favoured it, in fact, disproportionately, because so much of its sales were in the past. So as I've just foreshadowed, this run of 3 paragraphs starts on issues to do with the current licence being settled, flips to a point that's actually to do with how to unpack pre-existing licences, whilst muddling up the dispute, the much narrower dispute between Mr Bazant and Mr Mellor's way of assessing that, and then immediately flips back in paragraph 444 to a point that's directed to how to frame the FRAND licence being settled by the court. And the judge just doesn't seem to realise that these are not one single point in my submission. Finally, before turning to the points of principle he'd identified, the judge refers to a point about the effective date put forward by InterDigital and the fact that all past sales have been included in Mr Bazant's calculation of the sum due under the InterDigital offer. That's a rather freestanding claim. I don't think I need to trouble my lords with. The judge identified 6 points in paragraph 446 which he introduced by saying that it cannot be assumed that the approach advocated by either side is consistent with FRAND. And he suggests that point emphasised the points of principles he'd identified. And the first is described by the judge as whether, in unpacking an alleged comparable licence, account should be taken of the subjective views of either party to it. And he gives the treatment of past sales as an example, but says it has wider ramifications. And I'm going to come back to that in a minute, but just to complete the judge's list, the next is the point on whether the system of discounts, particularly volume discounts, is consistent with FRAND. Point 3 over the page is limitation periods and whether they have a role to play in the relationship between willing licensor or willing licensee. Point 4 is how to eliminate or discourage holdout. Point 5 is whether discounts, which the judge again acknowledges were often substantial in relation to past sales, should be part of the FRAND analysis. And he also identifies a related issue as to whether interest should be included on the past. And point 6 is whether it would be discriminatory not to apply discounts, e.g. for volume and past sales applied in the allegedly comparable InterDigital licences. And the judge said, this is 447, he found it convenient to discuss in this order. Although he says they developed over the course of time when considering and writing the judgment, and somewhat surprisingly to us, he suggests that only the issue on volume discounts was squarely raised, and the others were not identified by the parties, even though he says they were an issue on the pleadings. Now, the first point, the point on subjective allocation, we agree, that's all of the judge is making, but we don't really understand how the judge says everything save for volume discounts was not identified by the parties. We were arguing about things like what to do in a FRAND licence. Should they have volume discounts? Sorry, should they have past sales discounts? So that actually is quite puzzling, what he said there. Can I just pause and consider this group that in fact turn into 7 issues when he addresses them further in the following sections. But as he set them out there, I make the point again that the judge is not clearly distinguishing between an issue and how it may impact on the agreement one is settling, as opposed to how one has to address it when unpacking real-life licenses. Certainly this series of points appear to cover both kinds of situation. Some may consider both at the same time, although it depends how you read them. For example, issue 5, which is one of the 2 that directly relate to the issue of past sales, could, on one reading, just be understood as a point on how to deal with the issue in the licence one is settling, particularly as it's lumped together with the point on including interest, which obviously relates to the future licence. But that as a group, he's muddled them up in the sense that they, as a group, cover both types of scenario. And if we go back to issue 1, which is said to be one where the key example is past sales, this seems to be directed to the unpacking of real agreements, because it's about the subjective views of either party. And while we're on this, can I just make an important point about this? As framed here, one might read it as addressing the issue of whether, when unpacking, one should take account of subjective views of either party which are not shared by the other, or at least not known to be shared. That looks like what he's talking about. The problem is one that arises because the parties can and often will agree an overall deal without the individual moving parts. And so one is confronted with how to address an issue that the parties may not have separately agreed on. And we can go back to the point on units that we were discussing earlier. That's a prime example where they don't generally agree what the units were that were going to be included. The parties would have had views on units already sold and likely sold over the course of the future period. But they may also have an incentive to say they will be higher or lower because it will affect the overall sum payable. The licensee will want to say it's going to be lower, so they pay lower. Patentee will say the opposite. And that's why the experts' agreed approach generally is to use the objective measure of sales projected from the analyst's figures. But it's important to note that you only use those that are available at the time, as I've already said. And you're doing it because you don't know precisely what the shared view was, and in fact you're thinking that there probably wasn't a shared view. One's trying to work out what the deal tells you objectively about the unit price agreed, doing the best you can to work out what the number of units was likely to be considered. But what? Can I just ask my lords to stop and think, what if you did know in fact that they agreed particular projected sales? What if you did know that? So the units were in fact genuinely agreed. Perhaps you've got witnesses from both sides explaining why they did that. Perhaps it was unusual, but a not publicly known factor affecting it. Let me postulate something like there was a problem with the licensee's factories that meant capacity would be limited from the end of the year. Nobody else knew it, but they told the licensor. What I'm postulating is a situation where the subjective view of the parties as to the units is different to one that you would get from the objective assessment. But we know for sure that the parties did agree them as the basis for the deal. It may be a rare case, but it tests the point. In one sense, the agreed number of units is subjective of the parties, but it's shared. If you know it's shared, it doesn't really fit with the language that the judge uses here, where he refers to the subjective view of either of the licensor and licensee. Nor does it fit with the thrust of what he's getting at, which is, in my submission, that what you might stop and think about is where there's a subjective view of just one of them that's not shared. And my submission is that what the correct thing to do in the situation I'm postulating, where you are seeking to work out what the agreement tells you about the unit price agreed between the parties, would be that you do use the information that you know was common to the parties and shared. You need to be certain that they genuinely did agree it. Otherwise, you're deliberately proceeding upon a basis that you know will not give an accurate reflection. Now, why have I bothered to explain that to my lords at this time in my submissions? Because our issue is actually an issue which is complicated by two different levels of generality. at one level of generality, it's common ground between the licensee and the licensor that there will be heavy discounting for past sales. We can even look at the respective size proposals to see the ballpark that they were working to. At that level, it's subjective, but it's shared at that level of generality. The precise level of the discount was not agreed. So, in one sense, the view was not subjective because it was shared. In fact, the level that matters, the level of the existence of the heavy discount and the ballpark that we see the offers. But the precise allocation actually put in the accounts as the way to enumerate that was not shared. And my submission is, what the judge is failing to do is to recognise both of those here. What he's doing is, because the precise number in the accounts is not agreed by both, he's looking at that, focusing on that, but he's failing to recognise that actually at the more important level, the existence in fact of these heavy discounts and the ballpark in which they would be, it was a shared view, and in fact it was understood that that's generally how licenses operated because of the distortion in the market. And my submission is that at most, any worry about subjectivity can only play a part to the extent that one knows that that wasn't a shared or agreed view. At that level. And what's so strange about what the judge has done is back to the fact that he's muddled up the really quite narrow dispute between the experts as to precisely how you quantify it. He's muddled up the existence of that and perhaps a worry about whether or not you're looking at something that's too subjective, to then decide that I'm going to conclude that what everyone was agreed was a real thing and a big thing didn't exist at all. Can we move to look at the way in which the judge actually deals with these issues that he identified? But first is dealt with in paras 448 to 457. And the judge says there's a difference between the value of the payments in InterDigital's hands as opposed to focusing on the value of those payments made between the parties. I'm afraid this is another area where I'm really going to struggle to explain to my lords what the point is here. The judge himself says the distinction is obscure, but he says it's important. At 449, he says he can illustrate it by the two ways Mr Mayor unpacked the agreements that Lenovo relied upon. And he identifies the approach of blending across past and future, that's 449, and also dealing with, separately with the past and future, and that's 450. And the judge here notes the lack of an explanation from Mr Mayor for doing this, and speculates that it may have been for the purposes of comparison. And what the judge is talking about here appears to be at the stage of individual unadjusted rates derived from the agreements. So the agreements given in that upper table of the diagram reproduced in my friend's skeleton at page 9. And it may be the judge is right that Mr Mayor did it for comparison. But what the judge doesn't mention here is that Mr Mayor considered his separate past-future approach gave the better view of the economics, as we've covered that. And moreover, that the judge doesn't note that Mr Mayor may well have been presenting the blended past and future rate at this unadjusted point in time. He may have been doing that for comparison, but going forward from this stage, as I've shown you earlier, he only used the past-future split allocation for the remainder of his approach in his evidence, and then blended it up again at the end, as I've shown you. So the judge was puzzled, and returning to the judgment at 451, we see the judge explains how Mr Mayor had proceeded to present past and future rates, which we're familiar with, 10K allocation. And the end of the paragraph, he explains Mr Bazant used a similar technique, as we've seen. You've seen the judge notes here again, for detailed reasons they didn't always derive the same figure. And that's a reference to the delta again, the difference, the detail of the dispute between them. And paragraph 452 addresses Mr Bresky's evidence again and explains the relative fair allocation of consideration. And we see the top of 127, page 127, paragraph 453, with the repetition of the point about leeway as to apportionment, and therefore the judge's view of injecting significant subjective element to the analysis. And I repeat the point that I've foreshadowed already. An argument that there's a bit of leeway or inaccuracy that might, for example, have justified looking to LG's allocation, or perhaps some midpoint between the two. The two, I mean InterDigital's and LG's. One could understand, but this point is being used to justify completely ignoring the very real and very substantial effect that past sales have been subject to heavy discounting. And actually, paragraph 454 makes my point for me. The guts of this paragraph is that it's a very real thing and the discounts are significant. This is an important paragraph. The judge not only expresses that view, but explains what's caused the practice. It's what we've been talking about already, the difficulties in recovery, and the two main difficulties in recovery are also explained. Until recently, the SEP licensor, that licensor faced with the prospect of having to sue in many different countries, at least until Unwired Planet. And the judge saying, although it's now clear the UK has power to determine the terms of a global licence, and other jurisdictions are beginning to follow, it's clear that previous perception had a long-lasting effect in SEP licensing practices. An important finding of fact that I invite my lords to note well, please. The second reason given in para 455 is the perceived difficulty of limitation periods around the world. And the thrust of the explanation here is that implementers have an incentive to spin out negotiations for as long as possible, put the burden on licensors to sue within the limitation period to avoid losing royalties. Now, having identified this real effect and the reasons for it, the judge says, this is para 456, that when the claim is for the court to determine the FRAN terms, the question is whether this second perceived difficulty is real or not. And he says he's going to explain why it's not below. But just pausing there, again, he's looking at it in a point that suggests one should not include that feature in the FRAN licence you're settling. But that's got nothing to do with the fact that it's in fact been occurring and causing substantial discounts for the past in the existing agreements. I mean, obviously, the judge telling us what the answer is in this judgment, it's got nothing to do with the fact that it's already occurred, and indeed, that point is emphasised without the judge turning his mind to the need to address it as a separate matter in the comparable agreements in para 457. He finds that it's clear that these perceived difficulties have had a profound effect on shaping InterDigital's licensing practices, and those effects persist and are reflected in Mr Bazant's approach. I would add, as regards the crucial point, the different allocation of consideration to past and future, it's also reflected in Mr Mayer's approach. It was common ground. And the judge completely fails to turn his mind to the need to separate that effect out of the real-life agreements that he's looking at. In fact, the single one real-life agreement that he's looking at as a guide for pricing. Now, my lords, that mercifully completes the key section of the judgment I identified. There are a few bits worth picking up on in the remainder of this section, because I skipped over the whole of it, quickly on these points of principle. I hope I can take this a bit more quickly than that last section, which was quite a detailed trudge through those paragraphs. The judge turns to volume discounts, and we can skip over that pretty quickly because, as I've said, we don't seek to disturb his rejection of that aspect of our case. But what I do ask my lords to just note is that what the judge is rejecting is volume discounts of the size InterDigital was contending for. So, for example, at 495 at the foot of page 134 of the bundle, the conclusion is he's expressing there that the volume discounts said to have been applied in the range he identifies do not have any economic justification. And the ultimate conclusion at para 507 is that he's not saying volume discounts of any magnitude are not frank, and he refers to an answer that Mr Mayor gave that indicated, even in his view, relatively small volume discounts might not take the rate outside frank. And I also pick up a couple of points in the section where the judge deals with how to eliminate or discourage holdout. So it's the passage beginning page 144, paragraph 536. The judge refers back to the analysis of Mr Justice Mead in Optis F as to the point in time that an implementer must at the very latest be put to election. You see him refer to it earlier. It's the point when you found to infringe a valid set. And he says at 538 that at that point in time a FRAN licence must be available for acceptance. And he goes on to explain that the willingness of the licensee must be unconditional. And what I draw attention to here is a point that I'm going to deploy later on when we're looking at the conduct case. But it's implicit here that a FRAN licence must be available and is, even though the detail has not been determined, because the patent owner can rely on the fact that it's making one available by agreeing to offer whatever the court determines. So in other words, it's implicit in this analysis that the patent owner can and often will be offering a FRAN licence at a time when it's not actually been settled in the sense of the court resolved the fine detail of it. Moving on in this section, the judge makes the obvious point in 542 that an implementer who purported to say it was a willing licensee from this point onwards, but would refuse to pay for the past, was not in truth a willing licensee. And he goes on to make what is in substance the same point about a licensee who puts forward a variant on that, where they say they restrict both how many past sales they pay for, but whatever the period was. And he draws attention to the fact that others will have been paying and would ask why this particular implementer got away with not paying. And he develops this point further in para 544 by reference to the argument advanced by Mr Javaharian at trial, that if InterDigital have allowed either a complete pass release or heavy discounts for the past, it would be discriminatory not to allow Lenovo the same. And the judge's answer, that it's obviously both to the point that some sales would not be paid for at all, but some at a heavy discount, is in 545. And if you take it to its logical conclusion, it would mean Lenovo was entitled to be treated as the most favoured licensee. And he goes on in 545 to explain that that type of argument did not deter him from concluding what is FRAN, even if, particularly if, he concluded that licence structures applied to that date are not appropriate to be adopted in what he determines to be FRAN. Well, that's obviously right. The non-FRAN market distortion should not be included in the FRAN licence settled by the court. And I hope by now you have my submission, nor should its real effect of real-life licences be adopted in the information one takes from the real-life licences. Can we move forward and pick it up at 556? So I'm on page 148 of the bundle. Here the judge is summarising the effect of his findings on points of principle. And the first point he mentions is the finding that limitation periods have no role in the relationship between willing licensor and willing licensee. And he says this has a profound effect on the analysis. he explains not only must Lenovo pay in respect of its past sales, one of the other consequences is that the two reasons which he'd been able to discern as prompting the practice of heavy discounts have now been removed. And I think the other reason was the inability to get global determination. So that had been removed by the unwired planet case, which seems to be what he's referring to in the last sentence where global basis is referred to. Whereas before we look at the other conclusions, can I again pause and make the point? And I know it's repetitive, but he's only looking at things going forward. The question of what his FRAND license will look like, he's just not having any regard to the need to try to remove the effect of that non-FRAND market distortion from the existing real-life licenses. We can skip over the second finding, which relates to volume and other discounts applied by Mr Bazan, to the third point, which the judge makes at 560. Which refers to requiring the court to employ only objective measures rather than subjective views from either side in unpacking. Now, I've already mentioned that there must be a difference between a subjective view that's not shared to those which are known to have been a common basis for an agreement. Must be. And the judge says that these 3 points that he's just identified give rise to a number of beneficial effects, which he lists at para 562 to 566. Can we just look at the beneficial effects together? The first is the obvious point that his conclusion as to limitation should have the beneficial effect of removing the perverse incentive on implementers to string out license negotiations for as long as possible. We agree it'll help if understood as being seen in conjunction with his conclusion that the same rate should be paid for the past and the future units. Obviously, leaving aside the crucial point as to how one calculates that rate from the pre-existing licenses, of course. But we agree with what he says there, it will help. The application of the same rate for the past and future, subject only to present value adjustments in both directions, must also, as I've just said, be an important part of what the judge has in mind here. Second, para 563, the judge says the elimination of InterDigital's subjective views along with the limitation finding allows him to set on one side the subjective decisions as to what proportions of a lump sum they receive to attribute to the past and future. My lords, this is another very clear muddling of the issue of what to do in the future in the FRAND license agreement being settled and how one deals with non-FRAND features that are present in the agreements already agreed. The point can perhaps be highlighted by my asking my learned friend to explain to my lords how the decision being made in this judgment, the decision as to limitation that he's referring to here, can possibly enable the judge to set aside the subjective decisions made by InterDigital in the past as to what proportion of a lump sum they'd received. With the greatest respect, that is a complete non sequitur. Nothing the judge is deciding here can affect something that's already happened. And like the other reasons for heavy discounts, the inability to get global determination before fairly recent developments, it may be a cure going forward, or at least a help, but not an answer to the need to take it into account when looking at the past licenses. Whereas I would also say that you need to be very careful about the other limb mentioned here, the elimination of InterDigital's subjective views. As I've pointed out, it's just not right to characterise the view that there was a heavy discounting for past sales as a subjective view in the sense of not shared. Not at that level of generality. And in any event, what the judge is doing, prescribing an approach that pretends that there was no heavy discounting at all for past sales, in fact no discounting at all is to provide a cure that is worse than the disease. At most, that issue could only be relevant to that much narrower point as to how one quantifies the level of the discounts. What I mean by that is the dispute between Mr Mayor and Mr Bazant as to precisely how one quantified the thing that everyone agreed was a real thing. It makes no sense to move from a conclusion that there might be some leeway in the precise allocation as to the future rate, to go from that to a position where you pretend there was no heavy discounting at all. And so this third point, avoiding artificial inflation, is, I submit, a cure that's worse than the disease. And also, the judge's fourth point is also without merit. This is para 565. Here he says that the three previous points allow him to revert to employ the objective measure of any PLA favoured by the licensee and also favoured by other implementers wishing to understand something of the rates implied. I've already explained to my lords why they can do it both ways, because it's looking at the accounts, and of course they will try and do it, and they favour it. I don't disagree with the judge in saying these people favour doing that, but they favour it because it gives them a lower number. No more than that, it's complete self-interest. Likewise, the fifth reason, increased transparency, is also a flawed reason. If it's big enough to be reported, everyone could look at the details in the reports and they can do the calculations both ways round. And there might be scope for a little bit of a dispute of the kind that there was between Mr Bazant and Mr Mayor as to the future rates. But that is not, or would not justify saying, well, I'm going to treat the agreement with Party D in the hand-up that I gave my lords this morning as an agreement that the Frand rate was 19 cents. Certainly these last reasons seem to suggest that perhaps even the fact that sums are easier makes it preferable. That can't be a sound reason. Lords, that's all I wanted to pick up on the remainder of this section, and I just wanted to wrap up what I say you've seen. In my submission, you've seen a complete muddling of the two pairs of different points that I identified at the beginning of that longer section on the judgment. First and most crucially, the two distinct points that require separate attention as regards to heavy discounting for past sales, both ensuring it's not a feature of the future licence being settled, but secondly, removing the effect of the non-Frand feature from the existing agreements that are being looked at to extract information to use as a price guide. It's an error of principle not to address both. And the latter means taking a rate where the effect of the heavy discounting for the past has been removed. You should take it out. Secondly, the related pairs of points being muddled is the narrow point as to the dispute between the experts as to how one assesses or quantifies the past and future split of the consideration, and the leeway that individuals may have in pinning the precise number on that to give a rate for future sales, which will on any approach be significantly higher than the heavily discounted rates for the past. Muddling up that and the question of whether we take account of the significant differential at all, suggesting that is using an inflated rate. They're different points, and we see the judge using the existence of one dispute as justifying just ignoring that very real life difference. And an associated part of the dynamic we saw is the judge expressing a preference for avoiding the use of an assessment by one of the parties to the negotiation, which he calls a subjective allocation. And he goes from that to move from both experts proceeding in a way that took account of the substantially lower rates for the past to one where he's proceeding as if there was no discount at all. And that, in my submission, is just not justified. It's allowing a possibility for a dispute of a relatively narrow scope precisely where you plant the flag as to the differential allocation, to drive an approach where one ignores the reality of the effect totally. And it led the judge to make quite unjustified findings as to my client's allocation being creative accounting, and also in the form of order hearing that the auditors didn't consider the accounts on this point at all. And the judge had to go that far because part of his muddling up of these 2 points, having a differential at all and the leeway in an individual allocation providing some room for a dispute as to the precise size of the differential, has led him to use the leeway as the cause for the past-future differential existing at all. And it was particularly egregious and unfair because my witness was not challenged at all in his evidence as to the nature of how radically the judge was going to conclude my client's allocation was wide of the mark. The nature of how wide of the mark the judge was going to say my client's allocation was required him to have been challenged. Excuse me, as I said earlier, this is not the judge simply preferring some slightly different way to allocate the consideration. It's an attack on having a differential allocation at all under the accountancy rules for fair allocation, and it was simply not open to the judge to take that course when the evidence was not challenged in my submission. That's my attempt to highlight the key things that we say are wrong with the judge on this point. Can I turn to seek to address what I apprehend are Lenovo's answers to my submissions? And I'm hoping I might get through them before we break. Before I address what they do advance in their skeleton in response to my appeal, can I just point out what they do not say? First, they do not acknowledge in any way that it was their case at trial that there were very substantial discounts for past sales incorporated into the InterDigital licenses, specifically the Lenovo 7 they were relying upon, which obviously includes LG. They don't acknowledge that at all. Second, they do not suggest that as a matter of logic or principle, I am wrong that if there have been heavy discounts for past sales incorporated into a lump sum, that the principal thing to do, if you decide the discounting is not FRAND, is to remove the effect of those heavy discounts. I mean, it would be a difficult argument to advance. They don't do it. Instead, the points they make attempt to muddy the waters and suggest that I'm seeking to open up and re-argue the judge's assessment and evaluation across a wide range of issues and a great body of evidence and materials. But the reality is it's the opposite. Another tactic they resort to is to recite as many aspects of the judgment where the judge preferred their evidence or argument over mine. I don't know if they are hoping that subliminally my lords will think if we were unsuccessful on enough points, we deserve to fail even on the points that we were right on. But what my friend is just reciting things that I accept I've lost on and I don't seek to challenge. Strangely, they then criticise me for advancing my argument in the context of the findings the judge made and in relying upon the unpacking of Mr Mayor, as if that's a bad thing. Can we look at the detail of what they say? Can you take their skeleton? It's their responsive skeleton, so it's the one dated the 26th of April. I think if you're using it in the bundles, it's Core 2, Tab 7. Can I just pick it up at paragraph 12? So it's page 3, foot of page 3 of the document. You see a refrain that my lords will see again and again. Line 3 and 4 of this paragraph. The judge held there was no holdout with the largest licensees. Same point in paragraph 15, so the passage bridging page break between page 4 and 5. no holdout. As I've explained to my lords, that was quite a separate argument about the overarching depression to price we say has caused the large volume discounts. And they're right, we failed on that, as I've accepted, but it's just a different point. If we move forward to para 38, in case my lords have forgotten, paragraph 38, they tell you again that the judge's view there was no evidence to support the argument that the Lenovo 7 were depressed by holdout. And all this goes to the first of their two main answers, as I foreshadowed in my overview. And it's the first submission made from para 51 through to 55. So the heading submissions, and they go through and they make a series of 6 or 7 maybe. And it's the first one. And the argument is because the judge had held there was no hold up, the premise of my argument is wrong. As I've explained, it's just a different point. But this is their first submission, as I said earlier. One assumes they think it's their best. Para 51 refers to the judgment at para 726, which is in that section dealing with the separate overarching argument holdout. Para 52 is worth looking at because we see very clearly the way my friend wants to put the point. They refer to generalised evidence of a practice of giving discounts for past sales in the first line. And then they move to saying that cannot be said to an assertion that specific past sales in LG were significantly discounted. So the argument is that the judge's finding of no holdout for the Lenovo 7, as I've said, is actually a separate argument. The argument is that means there's no significant discounting for past sales in those agreements. That is the guts of what they're trying to say there. It must be a submission they make about all of the Lenovo 7, not just LG 2017. They don't have the courage to say it expressly, but that is the substance of what they're trying to say. And it's quite contrary to what was common ground and indeed positively relied upon by Lenovo. Past sales had been significantly discounted. And the problem for them is the judge has rightly found that practice is non-frand, a finding against which they do not appeal. And as I've said, it was common ground the practice existed and was present in the Lenovo 7 agreements that they were relying upon. So Lenovo is faced with a huge dilemma when it came to framing this skeleton. They've positively relied upon the heavy discounts for the past being in the Lenovo 7, but the judge has then held it to be unfrand. What do we do? Do we seek to appeal the finding that it's not frand, very difficult, or try to find a way out of the heavy discounts being in the agreement at all? And that's the way they've jumped. This is an attempt to get out of that pickle by suggesting that there was no heavy discounting for the past in the licenses that they were relying upon. And they seek to do that by pointing to the quite separate argument as to the overarching effect of holdout equating to the volume discounts. And that's what these paragraphs are basically seeking to do, my lords. And it will be worth asking my friend when he stands up whether that really is his submission, that there were no discounts for past sales in the Lenovo 7. Because that submission would be extraordinary given the case that was advanced at trial. Unless that is the submission, I can't understand the point they're seeking to make. It's their main answer, first submission here. Now the second submission, so that's made from paragraphs 56 to 60, is, as I've already foreshadowed, an attempt to argue that in fact the judge relied upon all the agreements in the Lenovo 6 or 7, at least as providing context to support picking the blended rate from LG. It's crucial that that's what they're trying to do. But I've shown you the judge was very clear. He only relied upon the single LG comparable, holding the others did not assist. And as I've already explained, the way they do this is to present figures in a diagram which is not comparing like for like, by mixing up future with future past blended rates, and by doing it before adjustment, you get a completely inaccurate picture. If your lordship wants to get into this, you should be looking at the Norwich City graph. That gives you the accurate comparison of future rates with those two adjustments that the judge accepted, giving you 2 bars for each agreement. Of course, the third point is back to the fact that we failed on the holdout argument as being responsible for volume discounts. That starts at paragraph 61. And the quote my friend relies upon is as to the jackpot case. It's from a part of the judgment where the judge is rejecting my argument as to the very large volume discounts caused by the overarching holdout argument. The passage they quote is all directed to that point as to whether there was also some overarching holdout depressing the rate. As I've said, we've lost on that and I don't seek to open it up. It's got nothing to do with the separate point of heavy discounts for the past, which was common ground. The third submission here is no more than a variant of the first, an attempt to set out the rejection of my case as to the overarching holdout causing the volume discounts that we relied upon. The fourth submission, paragraph 63 to 64, is an argument that I should lose because Mr Mayor's view was that it was better to take account of the blended rate. That's all it is. It's trite law that it's the reasons that count from an expert. And the fact that one is generally preferred doesn't mean you accept what he says on everything. All the more so when his reason is really just argument, or perhaps more charitably, I should just say an assumption as to what the aim should be. If the aim is to reflect what was agreed with the discounts that are not FRAND included in that effect, then fine. That was the point he was advancing. You'll recall I showed you paragraph 64.4 earlier on, and that's in this submission. But as I've said, that is not what one should be seeking to do. So the fourth submission is really simply seeking to say the judge should have assumed that the correct aim was to assess the totality of what was agreed without seeking to remove the non-FRAND effect of the heavy discounts for the past. Because Mr Mayor thought that was the correct aim. But it's for the judge, not Mr Mayor. The fifth submission, paragraph
Sorry,
6.
Mr. Smith, this is going to be one of those questions that indicates that I've not understood anything all day. So, Mr. Mayor, your complaint is that the judge has used a blended rate that Mr. Mayor put forward. That's the rate. There's 3 numbers. I don't know if they're confidential or not, but there's 3 numbers. One was the past, one was the future, and one was the blended rate. And your
Gone
complaint,
back to the unadjusted blended rate and then asked for new adjustment ratios.
Yes.
So he's used that going forward.
right. But doesn't the blended rate take account of the discount?
Yeah,
Because that's why it's blended.
But that's what I mean. You've got to take it out.
Right.
Right. This is quite important. Where's that sheet that I handed up? The worked examples, as my lord had them.
This thing.
Yeah.
Yes, yes, yes.
Each of these, the future rate is the same, $1 per unit.
Mm-hmm.
The blended rate is whatever you get when you average across the totality. go to the fourth table on my sheet, the blended rate, here we've called it the implied rate. But this is the approach of
That's not a
basically-
rate, that's a total. Oh, I see the blended rate at the bottom.
Yeah, the rate. So what you've let's take license D as the most extreme example. What Mr. Mayor has done is basically say you've got some that are $1, you've got some that are 10 cents. But if I weight it by number, I can tell you that it's actually 19 cents because 90% of them are at 10 cents. He obviously doesn't know the underlying numbers, but he's doing the calculation.
Yeah,
Basically says, I know there are two sets of sales that are in there, some at a high rate, some at a very low rate. But I don't care, I'm going to take the blended rate, so I'm going to say it's 19 cents rather than $1.
Right. Yes, no, I understand that.
Right, and my submission is that you've got to identify the effect of the heavy discounts, and in this case it would be 90 million units at 10 cents, and you've got to take that out, and you can work back and get to $1 a unit in each of these.
Sure.
In simple terms, your argument is that Mr. Meyer's preference for the blended rate is contradicted by the judge's findings as to the reasons for the discounts in the past.
Well,
And that's
yes,
a
I
very
see.
simplistic summary of
Yeah,
a whole day of argument.
Yeah,
That's what it comes down to.
Yes, I see.
yes, and you've got to take it out.
Yes. He takes, there's a sense in which the blended rate is taking something out.
Well,
Because
the
otherwise-
blended rate
otherwise
is
you
not
just
taking.
It's not taking anything out.
The blended rate is not taking anything out, and that's why he says you're not. It gives you a full appreciation of what was agreed as a whole. And I say, in a sense, he's right.
Okay, I see, all right.
It's a type of average.
No, funnily enough, I was there about an hour ago, and I lost again. There you are.
Thank you. I think I was on the fifth submission of their answers. The paragraph 65 is really kind of corollary of the fourth, where they say that you ought not to be doing what I suggested because Mr. Mayor preferred it. And what they're saying here really is just because Mr. Bazant did try to remove the effect of the price depression, and we're arguing that's the correct approach because he went to future overview. The submission is you shouldn't do it because Mr. Bazant did it. That's really no more than that's what they're saying. Now, obviously, in large parts, Mr. Mayer's approach was preferred. But this, in fact, is an extraordinary submission to suggest that it's to substitute Mr. Bazant's approach for Mr. Mayer's. We wouldn't be putting the rest of Mr. Bazant's approach in at all. We've just got this one thing that Mr. Bazant was doing, and in fact Mr. Mayor was doing in part of his unpacking. And all I'm saying is that the premise of Mr. Mayor is just wrong. And so this fifth submission doesn't go anywhere to just say, well, Mr. Bazant was doing it, so it would be wrong to do it because Mr. Bazant did it. You do it if it's right. The sixth submission is reliance on TCL in the US. As I've already foreshadowed, the choice that the judge appeared to be faced with in that case was to ignore the past sales completely as if they'd never happened, or unpack them at full value. Neither is right, certainly not on the facts as found here, that past sales were in fact given some value but at heavy discounts. And the seventh submission, starting at 68, relates to the specifics of the 10K filings. So it's not actually meeting the thrust of the general point of principle at all, the argument that there is a need to remove the non-frowned effect in any event. And the submission here actually muddles in the fourth submission all over again. They say that because Mr. Mayor preferred it, blended rate is the right approach. So that's the fourth submission repeated. And the rest of it under this submission is just submissions seeking to justify the judge's treatment of the 10K, even though they were relied upon by Mr. Mayor as reliable, relied upon by Lenovo as part of their case. We say they come nowhere near meeting the point that the judge was doing much more than simply saying there might be some other more accurate perhaps more objective way to quantify the thing that everyone was agreed was real and substantial. Nowhere near justifying throwing out the baby with the bathwater and not having any recognition of this very real thing, the substantial discounts for the past. And certainly, we say, for the reasons I've already explained, it does not justify ignoring Mr Bresky's evidence when it was not challenged. And the final point, the 8th submission, is their respondent's notice point, which is basically to suggest that the rate we seek would be discriminatory. And that is a submission where they have to rely upon not comparing like with like. The answer really is, in my submission, the same as my answer diagram included in at page 19. If you look at our correct presentation in the green and yellow bar graph, you see it's not discriminatory, it's within the range, and so their 8th point is really just a repackaging of the 2nd submission. Those are their answers, my lords. It really is thin gruel in my submission. And can I turn to address ground B, because it is really short and sweet. The issue of which economic adjustment to be used. It's entirely dependent upon my submissions as to ground A. And the point is, the economic adjustments that the judge had were calculated to be specific to the ratio as to the particular characteristics that they covered in the period to which they were applied.
Yeah. So, as I understand it, you accept that ground B can't succeed unless ground A does.
Absolutely.
And at the moment, I'm not detecting any reason from Lenovo for saying if it should fail if ground A succeeds.
Well, they seek in their skeleton to suggest that it's an overall evaluation, but it's a very precise number that's been calculated for the very precise period of time. But that's
right.
I think formally that's their submission. But my point is as short and sweet as my lord put to me. I'm not quite sure whether your lordships seek to rise now or 4:30. If I've got another 10 minutes, I can get some way down through the cross check.
We've had quite an intense day.
Yes,
I think probably it's best to.
I'm making good progress anyway.
Good.
These last points are much quicker.
All right, we'll pause and resume tomorrow at 10 minutes.